All right, welcome back. Well, we're going to be discussing the conflicting court orders. The CJN is disturbed by this, and so yesterday he summoned the chief judges of Rivers, Kebbi, Cross River, Anambra, Jigawa, and Imo to an emergency meeting to explain the current situation. Now, in the last couple of days, different blocks of the People's Democratic Party secured court orders restraining the party chairman and the acting chairman of the party from occupying the chairmanship position at separate times. A part of the invitation letter reads, if I could just go ahead and quote that, "My attention has been drawn to media reports to the effect that some courts of coordinate jurisdictions were granting conflicting ex parte orders on the same subject matter. It has become expedient for me to invite you for a detailed briefing on the development." Well, our correspondent also gathered that the meeting between the CJN and the heads of courts concerned is a prelude to a larger NJC meeting likely to hold next week. So we're keeping a tab on that and to get more details. Well, that is all we'll be discussing today, and we're starting off in Abuja. Makwa.
Thank you, Chamberlain. Well, welcome to Abuja Studios. We have with us this morning Mr. Adegboruwa, who's a senior advocate of Nigeria. Well, you might observe that the case in point which Chamberlain cited there, that of the PDP, has not been the only one. That of Anambra is also a case in point. So I'm wondering, sir, I welcome you to our studios in Abuja this morning, what you made of the CJN's intervention in this particular matter. Is it a little late, or would you say it's coming right on time?
Well, I think that, good morning, Mokwe and fellow Nigerians. I think that it's a bag of mixed feelings in terms of the intervention of the Chief Justice of Nigeria. And I say mixed feelings because when a judge is seized of the facts of a case, that judge is supposed to be dominus litis, to have full powers to decide the case without recourse to any interference from any quarter whatsoever. However, the Chief Justice of Nigeria, being the chairman and the head of the National Judicial Council, has the responsibility under the Constitution, along with other members of the NJC, for the discipline, promotion, and appointment of judicial officers. So to that extent, he has supervisory jurisdiction over judges, but it has to be limited to the extent to which it's a matter that is not meant to interfere directly in the discharge of the functions of judicial officers. So we have to be careful. It's desirable that indeed what is going on in the judicial sector in respect of Anambra and the position of the PDP be put under some kind of supervision. But at the same time, we must not create the impression that a judge is answerable in the discharge of his duties to any particular person. The judge is answerable to God, is answerable to his conscience, is answerable to law, subject to provisions of law relating to discipline. And so that's why I say it's a bag of mixed feelings. And I think it's commendable on the part of the Chief Justice of Nigeria. But you will note that this trend is not something that is new. Mm-hmm. And indeed, if you trace the history of this kind of conduct.
Which one of the trends now? The granting of
ex parte orders. Okay. It is to be laid at the feet of the government. A government is responsible for the abuse that is going on now. Because if you recall the history of Nigeria, even for the Chief Justice of Nigeria himself, you remember the circumstance that brought him into office. The immediate past Chief Justice of Nigeria was removed from office through an ex parte order filed by the government. I mean, somebody who had been in office for such a long time, and the procedure for removing him is in the Constitution, is that he has to go through the Senate. And the person was removed through an ex parte order. And not just that, you recall even in 1993, when Nigeria had the freest election in our history in this country, and we were rejoicing and thanking God, Muslim ticket, voted for by everybody in Nigeria, at midnight, a judge prompted by the federal government under the military then, annulled that election around midnight. And recently, you also recall that while resident doctors were on strike, and there was a negotiation going on, the Federal Ministry of Health went clandestinely to National Industrial Court to obtain an ex parte order. So really, I mean, you see, the trend is that it is the government that dictates what citizens will follow. Leadership is important. So indeed, what the people are doing is they're copying it from government. And I'm glad that both the NBA and NJC are standing up to challenge this. But I think that the real culprit in this matter is the government.
I think it's very important to state or to try and differentiate, because there are certain words we've both used now. We've used the word intervention, and you've also talked about interference. You know, in terms of describing how you feel about the intervention. I don't know whether to use intervention now or interference, but because they connote two different things. They carry two different meanings, even though they could be the same action that you're describing. So in this instance, would you say that the action of the chief judge, would you say it's an interference or is it an intervention?
Well, to the extent that it's meant to exercise the powers of the National Judicial Council, the CJN being the head of that council, it could be permitted under the law, especially under the Constitution. But if this intervention is, as the Chief Justice of Nigeria, making an attempt to control the way and manner in which individual judges exercise their discretion, that will not be welcome at all. Because indeed, once a judge, because, you know, we've been fighting for independence of the judiciary. What that means is that once a judge is sitting on a case, he should not be subject to any extraneous intervention, whether from the CJN, whether from the governor, or whether from anybody whatsoever. The judge should sit down based on the cold facts of the case before him and decide on it according to his conscience and according to law. So to that extent, we must draw some line between the intervention of the Chief Justice of Nigeria, and so that it does not get to the level of interference. It is to ensure that, looking at the circumstances of these cases, I mean, a judge in Rivers State granted an ex parte order, purportedly removing, or at least removing or stopping the chairman of the People's Democratic Party from parading himself as the chairman of the party. I mean, and it became a matter of national knowledge. Everybody in Nigeria knew that such an event had happened. So judges are permitted to take judicial notice of events going on in Nigeria. So to that extent, it will have been proper for all those who are concerned or affected by such order to go before that same court. Because the judiciary system is so wonderfully transparent, so that there is always room for you to challenge whatever order any judge has given, even ex parte. And if you do so ex parte and there's no remedy, then you go to the next level.
Because I was just about to draw your attention to the other instances which you enumerated, which proved somewhat controversial, and raised some debate amongst lawyers and even amongst ordinary Nigerians in the space. You've even gone back in history to as far back as 1993 to show how government itself has also used ex parte orders. Now, some people will say that there might be nothing wrong with using ex parte orders. The question is when they begin to come from courts of coordinate jurisdiction and they are given conflicting orders. Do you agree with that?
I agree to some extent. You know that the jurisdiction granted to courts in respect of ex parte orders arises in very extraordinary circumstances. And it did for us within the legal profession, is to say situations that become so urgent. For instance, somebody is to be executed and the person has an appeal pending. And if the sentence of execution is carried out, I mean, his life may not be available to pursue that appeal. In such circumstances, you could ask the court to say, please wait. In fact, we have circumstances in England when we were in law school in those days, when we were told that, I mean, a building was to be demolished and a judge was approached for an ex parte injunction. While in the bathroom, he dictated an order of injunction to his registrar or secretary to type it out and stop the demolition. So if there are circumstances that if you don't stop it immediately, irreparable loss may occur, then you could give ex parte order. It's proper. But because you are doing so behind the person affected, we normally do say that you exercise sufficient restraint, especially in cases in which you know nothing so irreparable will happen. The office of the chairman of PDP have been in existence since 2017, almost 4 or so years. Nothing could be so urgent, nothing could be so extraordinary that to warrant a judge to sit in Rivers and ask the occupant of that office not to parade himself or to leave office. Nothing, in my view, honestly, with due respect to the court where that order came from. So what the normal thing would be to say, go and put him on notice. Let me hear from him.
Okay.
Because so, the circumstance is not so urgent.
What I distill from what you're saying is that apart from the fact that we have been getting conflicting orders, the use of ex parte has also been abused. Is that correct?
Oh, yes, it's been abused. And, you know, because, and the reason why we are quite alarmed about what is going on is that once you get used to this kind of circumstance, because when you say injunction, injunction is to stop something. It's something that you just became aware of, maybe not like last week. But for somebody who has been occupying office since 2017, you can't say you are just getting to know about it. So we don't use ex parte orders to stop what has been completed. The man has been sworn in, he's been given mantle of office, he's been presiding over executive council meeting, he's been doing things to the knowledge of even the international community, how much less Rivers State. So when you want to grant such an ex parte or you are requested to grant such an order, it will be necessary for the person presiding over such court to exercise restraint to ensure that it's not abused. Because in June 2020, the Chief Judge of the Federal High Court had cause to issue a memo to all judges within that court on the need for restraint on granting ex parte orders. The National Judicial Council itself has made it a policy that ex parte orders should be granted in rare circumstances. In fact, in matters involving property, in matters involving cases that are so urgent that if you don't do something, there will be irreparable damage done.
So there is practice guidelines for the issue
there is
of ex parte order.
And it doesn't cover this kind of circumstance we are seeing in Kebbi, that we are seeing in Calabar, that we are seeing in Rivers State. No. When you want to grant an ex parte order, is to say, I can't reach the person. If I get to reach that person before the process of serving, before the process of coming back to court, some damage will have happened. Maybe, like I gave an example, maybe there's a ship that is in Nigeria and there's a controversy concerning money, concerning ownership. And if you don't do something urgently, the ship may go back and sail, and then you will not have opportunity to resolve the dispute. So you may get to court and say, please, the ship has just battered today and will be leaving next week. So please stop or arrest the ship while we resolve the dispute. Those are circumstances which we recognize in law. Or somebody has just served you a notice to say, we're going to demolish Channels Television, God forbid, tomorrow or next tomorrow. By the time you file your case and put the person who wants to come and demolish on notice, you probably have come to carry out such threat. So you say, please, in the meantime, maintain the status quo so that let me hear the reason why you want to demolish. But surely not something in which you have gotten to know that the person had occupied office since 2017, and then you approach the court. And it's not so bad, so annoying that such an ex parte order was granted. But that upon the grant of such ex parte order, somebody else again in Kebbi State, knowing that such an order exists, then granted another order that the person should assume office and resume. The chairman went to the office and resumed. And as they were about to hold the meeting, another court in Calabar, knowing that there was an order granted in Rivers, there was another order granted in Kebbi, another court in Calabar then granted another order, stopping him from assuming office, from presiding over meetings. So it became like a caricature. It was putting the judiciary in bad light, as if our house could not be put in order. And I think that's what has warranted the intervention of the CJN. But like I said, it must be an intervention that is not interpreted as maybe giving judges the impression that they have to be answerable to the chief judge in the exercise of their responsibilities, which is not the case.
Well, what I also find interesting is the fact that, because oftentimes they say, oh, the judges do not have to take cognizance of what is happening in the media space. However, in this particular instance, it would seem that the CJN has taken this action based on information from the media, and it would seem that judges are now required somewhat, because as you pointed out, when the expertise was given in Port Harcourt, the other courts could not have pretended that they hadn't heard the order as given in Port Harcourt, for instance. Does this change what should not happen? Because sometimes we hear that, oh, the judge can only act based on what is before it. It cannot, give more than what was requested or take into cognizance other circumstances around it. Is this changing for whatever reason with regards to ex parte motions?
No, it's not changing at all, Mokwe. What we say is clear. A judge is supposed to be neutral. That's why you see the eye of the logo of the lady. There's a cloth covering the eye of the logo of justice. In other words, it's blind. It doesn't recognize race, class, gender, or status. So it will just determine the case based on the facts presented before the court. That is sacrosanct. And I don't think we should depart from that. But the judge, however, is also entitled to take judicial notice of certain occurrences. I've been in court where a judge will say, well, I'm aware that my learned brother is handling a matter of this nature. I do not think it's proper for me to go into this case. Let me refer this file back to the chief judge and find out whether the facts are the same as the one being handled by my learned brother judge. And the reason is because courts are not supposed to give different and conflicting decisions in respect of the same subject matter. The same subject matter of the office of the PDP chairman is what is in Rivers State. And to that extent, once a judge comes in contact with a file requesting for an order that is contrary to what is going on in Rivers State, is entitled to take judicial notice and say, learned counsel, could you please address me concerning this matter? Are you aware whether there's a case like this pending in any other court in Nigeria? A lawyer is a minister before the court. He's entitled to tell the judge whether he's aware. If he's not aware, he will say so. Indeed, nowadays...
Can he feign ignorance? What if he says he's not aware, or he or she says, I'm not aware, and there is actually one?
Well, it's left for people who are aggrieved to show that, he may have been aware. Otherwise, if you say he's not aware and is genuinely not aware, there's nothing anybody can do about it. But the point I wanted to make is this. When this thing became an embarrassment to the judiciary, the chief judge of the Federal High Court also amended the rules of that court, and I think it should be done nationwide. If you want to file a case in the Federal High Court today, you are requested to file an affidavit separate from the course of action which you have brought to the court to ascertain that there is no multiplicity of action. To your knowledge, as a lawyer, as a party bringing this case before the court, that there is no other case, to your knowledge, in respect of the same subject matter pending, to your knowledge, you will swear that affidavit on oath, so that if it later turns out that you are aware and then you have come to mislead the court, it can be a ground to move that court to dismiss that case, or even to commence criminal proceedings against the deponent to such an affidavit who may have lied on oath. So that should be replicated in all judicial divisions and indeed in all courts, so that we can sanitize the system, so that we can save ourselves of this embarrassment about what is going on in the judiciary currently.
It would seem that the judiciary saw this coming because from what we understand, there was a circular issued by the Federal High Court talking about the grant of ex parte orders, hearing of cases from outside immediate territorial jurisdiction. And this circular was said to have been written sometime on the 24th of June last year, that's 2020, and it was addressed to all the honorable judges in the Federal High Court. It's saying something to the effect that it is of common knowledge that elections will be held in some states in Nigeria in the nearest future. The normal party conventions and primaries with attendant political maneuvering have already commenced amongst various political parties, which very often culminate in the institution of cases in the courts. In this regard, your lordships are strongly advised not to grant any ex parte injunctive orders in any political matter brought before your lordships. Now, it would seem that this has not been adhered to. Do you think that the Federal High Court had any powers in any case to be able to enforce this particular circular? Was it an advisory? Was it an instruction? Was it something that could carry, say, consequences as a result of them violating, as the judges, violating the circular?
Well, I think that the intention was quite commendable. I mean, in terms of trying to sanitize the system. But of course, like I said earlier, it's doubtful whether the administrative head of a court, chief judge, could, in any administrative capacity, restrain the exercise of judicial powers by individual judges. Because the power of a judge is as granted by the Constitution and also granted by law. So what the chief judge of the Federal Court has done is purely administrative, to ensuring that, I mean, we avoid the cases whereby we have conflicting and inconsistent cases or judgments in respect of the same subject matter. And the reason is very simple. If an election is to hold in Lagos, and there is dispute concerning the election or the primary election or the choice of candidate, there is no reason why a case concerning that matter should find itself in Abuja. Because the election is holding in Lagos. The candidates are to contest the election in Lagos. The constituency is in Lagos. So ordinarily, such a case should be filed in Lagos. But I think that the solution to this is to fund the judiciary and invest. Because the chief judge is himself the person assigning cases. So if a case had been filed yesterday, maybe to close down Channels Television, and I go there today to file another case, the system should prompt the administrative judge who is to assign the case to say, a case like that yesterday was assigned. So he will know the judge to which is assigned. But our system is manual. So there's no way you can track, the movement of cases to be able to know that a case concerning the office of PDP chairman was filed yesterday and is being filed today, is being filed tomorrow, so that the computer itself will ordinarily have prompted you to know that such a suit is existing. And I think that's what the chief judges should do, to make sure the system is automated to the extent that a subject matter of a suit that has been filed can be retained in such a system to prompt itself in case there is another suit filed in respect of the same subject matter. So it's a matter of funding, I think, and we can achieve that.
Yeah, but what I find interesting is the fact that the judiciary already saw this. They already predicted that this usually happens around political seasons. And if you look at the matters that are involved right now, they're all political matters. In the matter of the PDP and also in the matter in Anambra State, the forthcoming elections in Anambra State, I think the party has been most affected, even though, yes, the PDP in Anambra has also had its fair share. But APGA has felt the heat of this one as well. So if the Federal High Court, which is the court usually involved in this, and in some instances, state high courts are also involved in this, and they already saw this coming, did they really have any powers to be able to enforce anything to the contrary? Let me put it that way.
Oh, yes. The chief judge of the Federal High Court had done it, to my knowledge, when there was controversy concerning the composition of the board of the NDDC. And various cases were being filed in the various oil-producing states, in Calabar, in Delta, in Ondo. The chief judge issued a circular to all the judges and asked that all the files relating to the board of the NDDC be brought to Abuja so that they can be coordinated and avoid the situation in which another is being made in Port Harcourt, another order is being made in Akure, another order is being made in Abuja. And that was done. And that was how we were able to arrest that situation, to avoid the embarrassment. When this matter came up, it was possible for the chief judge of the Federal High Court to call for all the cases and be able to look at them and decide to send them back to the judicial division where the election is to take place. That is Anambra. And then secondly is this. Immediately this matter came up, appeals were filed. One of them was heard, and the judge or justices of the Court of Appeal berated the lawyers involved in those cases and recommended sanctions, both for the lawyers and the judges. If steps had been taken to enforce those recommendations by the Court of Appeal, what is happening now will not happen. Secondly, and that's the reason why I said government is to blame. Now, if this is done by, the cases are filed by government, for instance, the removal of the former CJN or the annulment of June 12 election, if sanctions had been granted against the people who perpetrated such ex parte orders or system, it will serve as a deterrence for other lawyers. But when the Minister of Health goes to National Industrial Court and procures an ex parte order, and nothing happens, because government has power to protect the people that is using for those systems, you cannot then wake up one day and be punishing lawyers who are representing private citizens. So the government should set the example.
Let me quickly put this in. Now that the state high courts are also involved in this matter, we see that it is the chief judges of the states that have been summoned. What powers do you think that the CJN can exercise in this regard?
There's none. With all due respect, the Constitution does not allow the Chief Justice of Nigeria to dictate to a judge in the exercise of the performance of judicial duties. However, the National Judicial Council, which is the body that appoints and disciplines judicial officers, can issue queries, can summon them, can ask for explanation. And if the explanations are not satisfactory, it can proceed to exercise disciplinary powers and recommend to the governor of that state for the removal or discipline, suspension of that particular judge. Other than that, we cannot, within our system, encourage the Chief Justice of Nigeria from Abuja to be dictating to what happened to cases in Lagos or in Port Harcourt. So this excess of power, it should be purely administrative, and it should not be encouraged. Otherwise, it will come to a situation whereby maybe another Chief Justice of Nigeria may abuse the system. Maybe he has a family dispute somewhere around Lagos and then use his power to ask the judge not to intervene. So we must draw a line between trying to avoid the embarrassment to the judiciary and then the independence of the judiciary itself in judges not being subject to anybody in the discharge of their duties except according to law.
Are you happy with the intervention of the NBA as well? They have written a statement in this regard, and they say they have noticed with dismay, those are their words, the happenings in the judiciary with regards to ex parte motion. I don't know what your take is, and when you look at the fact that the people who actually approach the courts are sometimes senior lawyers, and they are, of course, members of the NBA.
Yeah, one of the beauty of our profession is that it's self-regulatory and it cleanses itself. There is a body called the Body of Benchers, which has disciplinary power over lawyers. It is that body that calls lawyers to the bar and grants you license to practice. So the Body of Benchers has an organization called Legal Practitioners Disciplinary Committee. So to that extent, NBA and indeed the legal profession has a responsibility when matters like this happen to refer cases like this to that particular body to ask the lawyers to explain the circumstances, how you got to know that a case is pending in Rivers, is pending in Kebbi, and then you go to Calabar again in respect of the same case. So it's a welcome development.
So it should go beyond press statements for the NBA?
Oh, it should. The NBA should refer this matter to the Legal Practitioner Disciplinary Committee.
Mr. Adegboruwa, we have to thank you for your intervention. Yours is not an interference, certainly on this matter this morning. Thank you for coming and sharing your thoughts with us on this particular matter. Mr. Adegboruwa is a senior advocate of Nigeria.